Hello viewers, welcome to another episode of Public International Law on the Law Lab. As you already know, here on the Law Lab, we dissect and unpack everything legal and try to bring it to the barest minimum for everybody studying law or anybody interested in law to understand. Today we'll continue our series on the sources of international law as we started previously. As a quick refresher of the things that we've done, our first video in public international law looked at the sources of public international law. We identified that Article 38 of the statutes of the ICJ provides for some sources of international law, and it includes treaties or international agreements, international customary law, principles of law, and writings of scholars and judicial decisions. Today, we will go on to look at the second source of international law, which is international customary law. Right, so we'll jump right into today's discussions, and I hope that, as always, you find this very informative and useful. Now, our discussions on international customary law would take the following outline. First and foremost, we'll look at a definition for international customary law so that when we say international customary law, we'll be able to understand it and know what it represents. Secondly, we'll look at the elements that are necessary to establish anything as international customary law. And last but not the least, we'll look at the effect or the influence of consent on the existence of international customary law, whether or not it is important for a state to consent to international customary law before it is binding on such a person. Let's jump right into it now. Article 38 of the ICJ statutes, as we have already referred to, gives us the sources of international law, and the second, as stated in that article, is international customary law. Now, Article 38 would go on to define international customary law as evidence of a general practice accepted as law. Evidence of a general practice accepted as law. Again, in the commentaries of the draft conclusions on the identification of international customary law 2018, it's defined customary international law as unwritten law deriving from practice accepted as law. And last but not the least, Black's Law Dictionary, the 9th edition, would define international customary law as international law that derives from the practice of states and is accepted by them as legally binding. This is one of the principal sources or building blocks of the international legal system. And so you would see from the three definitions we've seen of what international customary law is that there are certain elements that are necessary for anything to be established as international customary law. From Article 38 of the ICJ statute, it says that international law is evidence of a general practice accepted as law. All right, it mentions general practice, and the second thing is that general practice must be accepted as law. Similarly, in the commentaries on the draft conclusions on identification of international customary law, it also says that international customary law are unwritten law deriving from practice accepted as law. Again, two elements are mentioned in this definition: practice, which is then accepted as law. And last but not the least, the Black's Law Dictionary will define international customary law as international law that derives from practice of states and is accepted by them as legally binding. And so these two elements of general practice, practice of states, practice that is accepted internationally, and the fact that that practice is accepted as legally binding on the states, or it's accepted as law by those states that practice it, would then be our two elements that are required to establish anything as international customary law. Let us look at these two elements deeper, and get a proper understanding of what international customary law is and how international customary law comes to being. As we have seen from the three definitions we have looked at previously, We have seen that international customary law develops from general and consistent practice of the states. And number two, the states that practice these things practice them as though or with the understanding that it is legally binding on them so to act. This is also known as opinio juris. In the case of the continental shelf, that is Libya, Arab, Jamahiriya versus Malta, the International Courts of Justice confirmed these two elements we have mentioned or seen from the three definitions of international customary law, and goes on to say that the elements of international customary law are that it is, of course, axiomatic that the material of customary international law is to be looked for primarily in the actual practice and opinio juris of states. All right, and so the judgment of the ICJ in the continental shelf case re-emphasizes or re-establishes these two elements that we have identified from the three definitions of international customary law as we've seen previously. Now let's take the first one, that is state practice. And what is state practice? How do we identify state practice or say that something that is done among states is constituent or constitutes state practice between these two states? For anything to be said to be state practice, all right, that practice has been seen to be, must be seen to be consistent or uniform, and that practice must have been done over a long period of time, all right? So that if state A engages in some practices in reference to another state B, that practice must be consistent that under the same given circumstances between state A and state B, it must be predictable that state A would do A, B, C, D. That is, it must be consistent. Number two, it must be done for all states in a non-discriminatory manner. You cannot do or extend a certain privilege to state B and refuse or fail to extend the same privilege to state C or D when they fall under the same circumstances as state B. And so if the practice is discriminatory in nature or the practice is not consistent irrespective of what states are involved, then that practice will fall short of what state practice really constitutes. So as an example, if Ghana as a sovereign state decides to extend diplomatic immunities to heads of countries that visit Ghana during their stay in Ghana, and it does so for, say, Togo, Nigeria, and Benin, it will not be state practice if Ghana does not extend the same privilege to countries like Cote d'Ivoire, Burkina Faso, or even China. And so it must be non-discriminatory. Similarly, if it does so for the president of Togo when he visits in 2025, as we are in now, it must do so in 2026 if the president of Togo chooses to visit Ghana. It must have done so in all previous visits of the Togolese president to Ghana. It must be consistent so that when any head of state is visiting Ghana on any occasion, he must expect, or they must expect, that Ghana will extend diplomatic immunities to this visiting head of state. So two very important elements are needed to establish state practice. It must be consistent and it must be done in a non-discriminatory manner. In fact, in the Nicaragua case, the ICJ says this of state practice. It says that the acts of the states must be uniform, certain, and consistent or non-contradictory over a period of time to be regarded as a state practice. It must be consistent to the point that when the state acts in a contrary manner, it is seen as breaching the existing custom and not rather as establishing a new custom. In other words, that state practice must be so consistent, must have been practiced over a long period of time that everybody that is visiting the country, or everybody would expect that the country would act in the same manner in respect of all other states. And that is what the Nicaragua case would say. If that state acts in a contrary manner, it must be seen as a breach of what has been established as a custom and not rather as an attempt to establish a new custom. That is the level of consistency that is expected of states in establishing state practice. And so that is to satisfy the first element of establishing international customary law, state practice as has been done over a long period of time, consistently and uniformly, and in a non-discriminatory manner. On the second element, which has come to be known as juris, opinion juris, which otherwise means that the states must practice them as though it is legally binding on these states. All right. What that simply means is that it is not enough for the state to do or engage in a certain act uniformly over a consistent period, over a long period of time. It is also very essential that the states must be practicing it as a matter of law, or that they must feel or practice that thinking that they are legally obliged to perform those acts for those states. All right, so let's give ourselves a little example. Every time a president or a head of state of another country visits any other country, it has become custom that the red carpet is rolled out for these visiting heads of states. They walk on this red carpet and they take a military salute from the armed forces of the receiving state. All right. That has been done consistently for a very, very long time by Ghana and all other international states. All right. It is, however, not enough to say that rolling out the red carpet, because it has been practiced among states for a very long time, is international customary law, constitutes international customary law. What anybody needs to establish, secondly, apart from the long, consistent practice, is the fact that the states regard this practice as legally binding on them. And that is what we know or we call opinio juris. Now, the Black's Law Dictionary would define opinion juris as the principle that for conduct or a practice to become a rule of customary international law, it must be shown that nations believe that international law, rather than moral obligation, mandates the conduct or practice. In other words, Black's Law Dictionary is saying that when you perform these acts which has become state practice, it must be clear from your actions and from the things you do that you are doing this practice not because you have a moral obligation so to do, but rather because you feel like you are legally obliged, or you're under the impression that you are legally obliged to do those acts that you do. Similarly, in the North Sea Continental Shelf cases, the ICJ characterized opinion juris as follows: a belief that a practice is rendered obligatory by the existence of a rule of law requiring it. And so, in the North Sea Continental Shelf case, the court is saying that opinion juris is the belief that a practice is rendered obligatory by the existence of a law. It is important to note that without the existence of an opinio juris, all right, which is considered the psychological element of customs, state practice, no matter how consistent and widespread, will not transform into international customary law, as was held in this North Sea Continental Shelf case, pardon me. Again, similarly, in the case of Germany versus Italy, all right, which is known as the jurisdictional immunities of the states, the court was of the opinion that how do you establish, or the court was concerned with giving some guidelines as to how to establish that these nations are engaging in a practice as a matter of a legal obligation rather than a moral obligation. Because it is often said that even the devil himself does not know the mind of man. And so how would anybody establish that the psychological element required for the establishment of international customary law is present? All right. And the courts had this to say in the Germany versus Italy case, which is also known as the jurisdictional immunities of the state. Opinion juris in this context is reflected in particular in the assertion by states claiming immunity that international law accords them a right to such immunity from the jurisdiction of other states. In the acknowledgement by states granting immunity that international law imposes upon them an obligation so to do, and conversely, in the assertion by the states in other cases of a right to exercise jurisdiction over foreign states, While it may be true that states sometimes decide to accord an immunity more extensive than that required by international law, for present purposes, the point is that the grant of immunity in such a case is not accompanied by the requisite opinio juris, and therefore sheds no light upon the issue currently under consideration by the court. In other words, it is important for two things to also be established in deciding whether a practice is as a matter of opinio juris or moral obligation. The first thing is that the state that is doing the practice or extending the privilege to another state must know and expect that it is obligatory on themselves to do so. The state that is expecting, or the state to whom that privilege is to be extended, must also come to expect that treatment from the other state because it regards it as a matter of law binding on them. In other words, or the principle that is important for us to derive from the Germany versus Italy case is that by the actions, utterances of the states that are performing these states' practices or states' obligations, one would be able to determine whether or not there is opinion juris in the way that the nations have conducted themselves. And so it would suffice to say that it is very subjective and it will be determined on a case-by-case basis by the courts if there's a dispute as to whether or not anything that has been done with opinion juris and not moral obligations. Now, in our studies of international treaties, or in our discussions of international treaties in the previous videos, we saw that it is important for a nation in the exercise of its sovereignty to express consent to be bound by an international agreement, right? And so, without the consent of a state, an international treaty will not be binding on that state. Is this consent also necessary in establishing or in binding another state in what has become an international customary law? So that if any practice has been constituted as international customary law, must any state express consent to be bound by that international customary law before it becomes actually binding on that international customary law? Let us use the case of Ethiopia-Eritrea Claims Commission to determine whether or not there is a need for consent. In the Ethiopia-Eritrea Claims Commission, the courts had this to say of consent in whether or not the role consent plays in binding states to international customary law. The courts, the matter in that case, or in claims number 4, was that Eritrea, which had then broken away from Ethiopia through conflict and had become a sovereign state, was not a party to the Geneva Conventions on how states must behave in times of war. All right. So the matter that was before the courts to determine was whether or not Eritrea, not being a party to the Geneva Conventions, should be bound by the provisions of the Geneva Convention. The international court in that matter said that even though Eritrea was not party to the Geneva Conventions, the Geneva Conventions had been so widely practiced over a long period of time that it had moved from the realms of an international treaty into an international customary law. And as such, Eritrea did not have to be a party to the Geneva Conventions before the provisions in the Geneva Convention would be binding on them. In other words, what the court is saying is that as long as something has been practiced over a long period of time and has been established as international customary law, it does not matter whether or not the country has expressed consent to be bound by that international customary law. Similarly, in the Nicaragua case, the dispute was also about a treaty that existed between America and some states in America as a continent. All right. America was a party to those treaties. However, it expressed reservations on some provisions of the treaties. And so if it was a matter of only international treaties as existing between the states, those provisions will not be binding on the US as a sovereign state. However, When this matter was to be decided upon by the ICJ stated that those provisions for which the United States had expressed reservations and did not want to be bound by those provisions, because those provisions had transcended international treaties and had now reached or had been established as international customary law between those states, America could not remove themselves from the obligations that were placed on them by virtue of those provisions, even though they had expressed their reservations towards those provisions. And so from the two cases that we have just seen, that is the Ethiopia-Eritrea Claims Commission and the Nicaragua case, it is evident that consent to be bound in international customary law is very, very diminished, or is not as important, as relevant as it would be in the case of international treaties. This would mean then that a state does not need to express consent to be bound by an international customary law before the courts would deem it binding upon that state. And so, ladies and gentlemen, this brings us to the end of our video on international customary law. I hope that you have found this video very insightful, and it's helped you to understand what constitutes international customary law and how international customary law is developed. I'd want to take this opportunity to urge you to subscribe to the Law Lab, as there are more educative videos which I'll be bringing your way. And please don't let it end there. Click on the notification bell so that when new videos are uploaded, you may be notified of them. And do well to share same with your friends who are also interested in the subject of law or are pursuing an LLB course in Ghana. Thank you very much. And as always, my name has been Adamu Ben Mahmoud. Until next time, have a good day.